Okay, welcome everyone. Thank you for taking the time to be here today. My name is Jeremy Kritt. I'm an associate attorney at the law offices of Marc J. Lane. I'm joined today by my colleague Joshua S. Kreitzer, who's a senior associate attorney here at the firm. And we are corporate and tax attorneys who do a lot of work with different forms of social enterprises as part of our practice. And of course, benefit corporations are a form of social enterprise. So today's webinar is on benefit corporations pursuing purpose and profits. So before we get into the content today, I want to start off with a little poll question to get to know each other. So you'll see 4 options here up on the screens. And once you choose an option, let me know what your objectives are for being here today. You either A, want to start a business that has social and or environmental goals. You have a business and you want to start pursuing those goals. You have a business that already pursues those goals and want to keep pursuing them. Or maybe you are just a consumer who's interested in learning more about socially and environmentally responsible businesses. So I'll give everyone just a few minutes here to answer the poll question. Looks like we got a mix of answers, which is always good. Just give everyone one more minute here. Okay, great. So it looks like everyone falls into either A, C, or D. So you either all have all want to start a business or already have a business that's pursuing social and or environmental goals, or you're just a consumer that's interested in learning more. So why don't we go ahead and use those objectives to start kind of contextualizing the benefit corporation. So you have those objectives and let's say you want to start a business with social and environmental objectives. So what entity structure would you start off with? Well, you might consider the non-for-profit corporation. But the problem with a not-for-profit corporation is it's only designed to facilitate social objectives. A nonprofit must be organized solely for charitable, educational, or other similar purposes. As the name implies, it cannot be operated for profit, and it does not have owners or shareholders, and thus it can't issue dividends or make distributions. The economic potential of a non-for-profit is limited. Now, on the other end of the spectrum, you have a for-profit corporation. And the problem with a for-profit corporation is it's only designed to facilitate financial objectives. A for-profit may be organized for any lawful purpose. Directors and officers have no duty to manage the corporation sustainably or even to consider social or environmental factors in their decision-making. And for a variety of reasons, which we will get into, the decisions of directors and officers are typically driven by the goal of maximizing shareholder value. Now, even if there are social or environmental purposes, there's really no legal mechanism to enforce those purposes. Now, the last thing I want to distinguish the benefit corporation from is the certified B corporation. I'm sure many of you are familiar with the certified B Corp, but you see the problem with the certified B Corp from the perspective of what entity structure you're going to use is it's not an entity structure at all. It's a third-party accreditation. You take a third party's evaluation, and if you meet certain criteria, they will certify you as a B corporation. But it is not a starting point. Generally, you do need to become a benefit corporation to get B Corp certified, but you still must start off with a legal entity. So then that brings us to the benefit corporation. So what is the benefit corporation? Well, benefit corporations were created primarily as a response to the existing legal framework governing officer and director decision-making. Officers and directors of a corporation are generally considered fiduciaries of the corporation. Then, as fiduciaries, they have a duty to act in the best interests of the corporation. So then what are the best interests of the corporation? Well, here you have a very famous quote and case in the corporate law arena here up on the screen. It says, a business corporation is organized and carried on primarily for the profit of stockholders. The powers of the directors are to be employed for that end. So what this illustrates is the concept that's known as shareholder primacy. And shareholder primacy is the idea that what's in the best interests of the corporation is always increasing the value of that corporation. The extent to which shareholder primacy applies today, it is subject to debate, and it definitely varies in different contexts. Management's day-to-day decisions are typically given the most deference by courts. But then when we get into situations involving defensive measures or change of control, shareholder primacy does become a much more significant factor. And in any event, the extent to which, in the manner in which the existing corporate framework will apply to a social enterprise, it's uncertain. And this can be illustrated by the case eBay Domestic Holdings versus Newmark. And this case happened right around the time that the benefit corporation was initially created. It's a very new form of entity. And briefly what the situation was in this case, on one side, you had the founder and CEO of Craigslist, and on the other side, you had eBay, who was a minority shareholder of Craigslist. And the founder and CEO of Craigslist, they viewed their company as more than just a strictly commercial enterprise, as a public good, a community service. And they got into a dispute with eBay, and ultimately they lost. And part of the court's reasoning is up here on the screen. It says, directors of a for-profit Delaware corporation cannot deploy a rights plan to defend a business strategy that openly eschews stockholder wealth maximization, at least not consistently with directors' fiduciary duties under Delaware law. Now, to be clear, today's presentation will not be focusing on Delaware law, but this does illustrate the need and the purpose behind a benefit corporation. So then what is a benefit corporation? Well, it's a for-profit corporation. And as a for-profit corporation, it has owners and shareholders and has unlimited economic potential, both for the business itself and shareholders. But then it's also subject to additional statutory requirements, additional required purposes, different fiduciary duties, and an obligation to report on social and environmental objectives. Here you have just some big name examples of benefit corporations, just to give you some context about what we're talking about here today. And to be clear, none of these are Illinois benefit corporations, but almost every state in the country does have either a benefit corporation law or some variation of the benefit corporation. These include public benefit corporation, sustainable benefit corporation, social purpose corporation. There's a lot of different variations. And to be clear, that each individual law does vary to different degrees from one another. And today we will be focusing specifically on Illinois' Benefit Corporation Act. But just kind of as a general matter, all these different offshoots and subsets, they generally share three defining features. Purpose, generally must have a purpose that benefits the public in some way. Accountability, there's expanded fiduciary duties. and transparency, obligation to report on overall social and environmental performance. So that brings us to the focus of today's webinar, and that is the Illinois Benefit Corporation Act. So the starting point for understanding any of the unique features and aspects of the Act is the Illinois Business Corporation Act, and just regular traditional corporate law. A benefit corporation, to be clear, it's still a corporation, so it's subject to all the requirements that an Illinois corporation is subject to. But then it also voluntarily elects to become subject to additional requirements and additional provisions under the Illinois Benefit Corporation Act. So how do you become a benefit corporation? How do you start one? Well, you either start from scratch and incorporate a benefit corporation, or you elect to have your existing business become one. To incorporate as a benefit corporation, as I mentioned, the starting point is always what you would do with any corporation in Illinois, and that's file articles of incorporation. But for a benefit corporation, those articles of incorporation must also state that the corporation is a benefit corporation and must also include additional purposes. To elect to become a benefit corporation, again, all that's required is the articles having those two additional requirements. So the articles must be amended to include those requirements. And under the Benefit Corporation Act, that amendment, or if it's a merger or reorganization and the surviving corporation is to be a benefit corporation, it must be approved by what's called the minimum status vote. And to briefly summarize, the minimum status vote is the shareholders of every class or series are entitled to a vote, and 2/3 of the outstanding shares all must vote in favor of the action. So that brings us to the first kind of key feature that I mentioned of the benefit corporation, and that's purposes. So here you have the statute. A benefit corporation must have a purpose of creating a general public benefit, and a benefit corporation's articles may also identify one or more specific public benefit purposes. Now, the key language here I want to point out that's in bold on the screen is the creation of general public benefit and specific public benefit is in the best interests of the benefit corporation. So here we have the statute kind of explicitly saying that, hey, not only are shareholder interests and shareholder wealth maximization in the best interests of the benefit corporation, but explicitly the general public benefit and any specific public benefit are in the best interests of the benefit corporation. So again, the starting point is always Illinois Business Corporation, just traditional corporate law. Corporations can be organized for any lawful purpose. Benefit corporations must create a general public benefit and may also create one or more specific public benefits. So, I've said the phrase general public benefit many times at this point. What does that mean? Well, a general public benefit means a material positive impact on society and the environment, taken as a whole, assessed against a third-party standard from the business and operations of a benefit corporation. Now, that's definitely a bit of a mouthful, but a few things that I think that are important to point out is, material positive impact taken as a whole from the business and operations. The intent is for the positive impact of the benefit corporation to really be viewed holistically, the kind of the net impact of the benefit corporation. And then the really important language here is assessed against a third-party standard. Now, obviously, kind of at a high level, general public benefit, material positive impact. These things are subjective, admittedly. So what the assessed against a third party standard does, which we will discuss the third party standard in greater detail, is it injects some objectivity. It gives meaning in a way to measure what it means for there to be a material positive impact. Then the benefit corporation also may have an optional specific public benefit purpose. Here you have the statute on the screen, and in many ways it kind of lists different examples of specific public benefit. You'll see the last one there is kind of a catch-all, the accomplishment of any other benefit for society or the environment. So you really, a key feature of the statute that's going to appear over and over again is flexibility. Many benefit corporations may not want or need to include a specific public benefit purpose. But, say, for example, you had considered starting a not-for-profit corporation, but the lack of economic potential really dissuaded you from doing so. Well, this could be a way to kind of marry those two objectives of you want to address, have a little bit more specific of a mission than just a general public benefit, but within the confines of a for-profit entity, this is an additional feature that you might utilize. So now we will move on to the next key feature, transparency, and I will kick it over to my colleague, Mr. Kreitzer, to take over from here.
Thank you, Jeremy. Yes, I will be talking about transparency as it relates to benefit corporations. Okay, so there are some things that are needed to inject objectivity into the benefit corporations activities. The one is a third-party standard, and is the other the annual benefits report. Because standing alone, what it means to create a general or specific public benefit is subjective, and what a material positive impact on society and the environment taken as a whole means is also subjective. And we see that in relation to greenwashing, which we hear about sometimes, and that's branding and marketing designed to convey a false or misleading impression that a business is environmentally and or socially responsible. So that is why we have the third-party standard and the annual benefit report. The third-party standard provides the means to objectively measure the benefit corporation's impact, and an annual benefit report provides a means to evaluate the benefit corporation's impact. A third-party standard is a standard for defining, reporting, and assessing the overall corporate, social, and environmental performance of a business. The statute does not identify a specific third-party standard. Benefit corporations are free to use any standard that meets the statutory requirements. And flexibility is a key feature of the third-party standard. The statute, as I said, does not identify a specific third-party standard or provide a specific way to measure and weigh the various interests and factors that must be assessed. And for example, B Corporation certification is a third-party standard, which was mentioned before and during Jeremy's presentation. There are many third-party standards to choose from, and each has advantages and disadvantages. Potential factors to consider when selecting one include cost, complexity, whether it's general versus industry specific, geographic location, any accompanying certification or accreditation, and popularity or other marketing benefits. So what interests and factors must be taken into account in measuring social and environmental performance? The third-party standard must comprehensively assess the impact of the business and its operations on, one, the employees and workforce of the benefit corporation, its subsidiaries and suppliers, the interests of customers as beneficiaries of the general public benefit and or specific public benefit purposes of the benefit corporation, community and societal considerations, including those of each community where the offices or facilities of the benefit corporation, its subsidiaries, or its suppliers are located, and the local and global environment. And this helps to give meaning to a general public benefit purpose. So then we have the issue of objectivity and reliability. A third-party standard must be developed by an entity that is independent, credible, and transparent. By independent, we mean that the third-party standard must be developed by an entity that is free from conflicts of interest. It cannot have a material financial relationship with the benefit corporation or any of its subsidiaries, and it may not be materially financed by, and nor can it have more than 1/3 of its governing body representatives be one, associations of businesses operating a specific industry, the performance of whose members is measured by the standard, businesses from a specific industry or an association of businesses in that industry, or businesses whose performance is assessed against the standard. And it must be credible. That means that the standard must be developed by an entity with appropriate expertise and using input from the public. And it must access necessary and appropriate expertise to assess overall corporate social and environmental performance. And it must use a balanced multi-stakeholder approach, including a public comment period of at least 30 days to develop the standard. And the standard must be developed by a third party that is transparent as to how it developed the standard and why it is independent. It must make available the following information about standard. One, the factors considered when measuring the overall social and environmental performance of a business, and the relative weight, if any, given to each of those factors. Two, the identity of the directors, officers, any material owners, and the governing body of the entity that developed and controls revisions to the standard, as well as the processes by which revisions to the standard and changes to the membership of the governing body are made, and an accounting of the sources of financial support for the entity with sufficient detail to disclose any relationships that could reasonably be considered to present a potential conflict of interest. And we'll also talk about the annual benefit report. And this is an annual report that describes and assesses a benefit corporation's environmental and social performance. And it is somewhat analogous to annual financial statements, because financial statements provide the objective metrics and information needed to evaluate financial performance, and they can be used by shareholders to evaluate management success in achieving financial goals, and by potential investors to evaluate financial performance of the company. And similarly, the annual benefit report provides the objective metrics and information needed to evaluate social and environmental performance. It can be used by shareholders to evaluate management success in achieving social and environmental goals, and it can be used by potential investors and customers to evaluate the social and environmental performance of the company. Sorry, I'm looking for my slide control here. There it is. And what must the annual benefit report contain? It must contain an assessment against a third-party standard. That is an assessment of the overall social and environmental performance of the benefit corporation against a third-party standard. And in case there's any ambiguity about this, typically the assessment is made by the company itself, generally by the benefit director or officer, which is something that will be discussed later. But it's not, the assessment is not solely performed by an outside party. The assessment is measured against a standard created by a third party. And the report must also contain information about the use and selection of the third-party standard, the narrative description of the process and rationale for selecting that third-party standard, and the report's assessment against a third-party standard must either be, one, applied consistently with prior benefit reports, or if not, it must be accompanied by an explanation of the reason for any inconsistency in the application. And the report must also contain a public benefit purposes narrative, and that would be explanations regarding the corporation's pursuit and creation of its public benefit purposes. And this must include narrative description of the ways in which the benefit corporation pursued general public benefit during the year and any specific public benefit purposes that are included in its articles of incorporation, the extent to which the benefit corporation created general public benefit and specific public benefit, if applicable, and any circumstances that hindered the pursuit of general public benefit and specific public benefit, if applicable. The report must also contain an opinion by the designated benefit director regarding whether the benefit corporation acted in accordance with its general public benefit purpose and any specific public benefit purpose in all material respects during the period covered by the report, and whether the directors and officers complied with their special duties, which are discussed later, and if they did not, a description of their failure to comply. And I will skip back here a second. Sorry. Okay. The benefit director is essentially an independent director responsible for preparing the annual benefit report. Illinois requires a benefit director. Many states make it optional. There's also the opportunity in Illinois to have a benefit officer. The idea is that this person would be in charge of fulfilling the company's mission of social purpose. The report must also contain the director, officer, and owner information. That is the name of the benefit director and the benefit officer and their contact information. The compensation paid by the benefit corporation during the year to each director and the capacity of a director. The name of each person that owns 5% or more of the outstanding shares of the benefit corporation, either beneficially to the extent known or of record. A statement of any connection between the organization that established a third-party standard or its directors, officers, or material owners, connection with the benefit corporation itself or its directors, officers, or material owners, including any financial or governance relationship that might materially affect the credibility of the use of the third-party standard. And if the benefit corporation has dispensed with or restricted the discretion or powers of the board of directors, that's something that might occur in a closed corporation, which is essentially run by the stockholders in lieu of the board of directors, then the annual benefit report must describe the persons who exercise the powers, duties, and rights and have the immunities of the board of directors and the benefit director. And what must be done with this annual benefit report? It must be sent to shareholders annually, and that would be within 120 days after the end of the fiscal year, or at the same time any other annual report is delivered to shareholders. And the report must also be made publicly available. It must be posted on the public portion of the benefit corporation's website. If there is no website, it must be provided for free to anyone on request. However, the publicly available version can omit the compensation about the directors, the compensation for the directors, and any financial or proprietary information. Some states require the benefit report to be filed with the Secretary of State or a similar state agency. Illinois does not. And so I will turn this back over to Jeremy, who will be discussing accountability.
Okay, so there are the final key feature of the benefit corporation is accountability. And really the first aspect of that is director and officer standards of conduct. So as I've discussed at the start of the presentation, the starting point for all benefit corporation law is just traditional corporate law. And under corporate law, all officers and directors, as I discussed, have a fiduciary duty, which requires them to discharge their duties in good faith, with the care that an ordinarily prudent person in that position would exercise. And a very important part of what it means to act as a prudent person is you must act on an informed basis. Prudent people make decisions based off all of the relevant material information available to them, and then in a manner reasonably believed to be in the best interest of the corporation. So benefit corporations are subject to existing corporate law unless the Benefit Corporation Act provides otherwise. So what does the Benefit Corporation Act provide? Well, it says in discharging the duties of their respective positions, the board, committees of the board, individual directors, in considering the best interests of the benefit corporation, shall consider the effects of any action upon. So directors must consider the effects of any action upon these 7 different categories of interests and factors and stakeholders. Now, the first one, they're the shareholders of the benefit corporation. To be clear, just because the benefit corporation was kind of created to give a tool to not let shareholder primacy and financial value dominate decision-making, this is still a for-profit business form, and shareholder interests are still must be considered in any corporate decision. Then you'll see that the next 4 factors listed: employees and workforce, the interests of customers, community and societal considerations, the local and global environment. If you'll recall, those were the 4 factors that the third-party standard must assess. So you have what's the definition of general public benefit? Well, what gives it objectivity and gives it meaning is the third-party standard. So this is really saying, the directors not only just need to consider general public benefit, but actually the individual factors that kind of provide meaning to general public benefit. Then you'll see F there, the short and long-term interests of the benefit corporation, including benefits that may accrue from its long-term plans and the possibility that these interests may be best served by the continued independence of the benefit corporation. So in a lot of ways, what that is kind of getting at is the idea that directors of and officers, management of a benefit corporation, they need to have the ability to make decisions that may not necessarily maximize short-term financial value, but are in the best interest of not only the corporation, but its ability to kind of accomplish its general and specific public benefit purposes, and not just necessarily have to, sell to the highest bidder or whatever the case may be. And then the last one there, more of a general consideration, the ability of the benefit corporation to accomplish its general and specific public benefit purposes. So directors may also consider, and that's considerations listed in Illinois' constituency statute, and any other pertinent factors or interests that they deem appropriate. Again, it's intended to be flexible and to give directors some leeway, but critically, directors need not give priority to the interests of a particular group or person over the interests of another group or person, unless the articles of incorporation state that they do. So what this statute does is, it legislates the decision-making process. It doesn't legislate results. Now, at the same time, the Benefit Corporation Act is intended to be flexible and really gives those who are setting up and creating the structure of a benefit corporation a lot of flexibility in determining how they want decision making to work. When it comes to officer standards of conduct, they are essentially the same. So where an officer has discretion to act and it reasonably appears that that matter may have a material effect on general or specific public benefit purposes, the officer must also consider those same interests and factors that directors do. So what these standards of conduct do is, first of all, they essentially expand the concept of what it means to be in the best interests of the corporation. As I'm sure you're starting to see the common theme here, the best interests of the benefit corporation of course, include the impact on shareholders of any corporate action or decision. But now the best interests of the corporation are statutorily defined to include all of these additional factors: employees and workforce, customers, everything that was listed on the statute slide a little earlier. And it may also include other pertinent factors or interest directors deem appropriate. The idea here really is the act allows for decisions that do not solely maximize financial value. Now, at the same time, while it protects management, it also expands the scope of their duties. It really expands the concept of what does it mean to meet your fiduciary duties and to act on an informed basis. To act on an informed basis now explicitly means you have to have considered all of these additional interests and factors. The act imposes additional duties on decision making. But again, the act does not establish how the various interests and factors should be balanced or what interests should be prioritized. The act is really focused on the decision-making process and not the end results. Now, some additional features of the standards of conduct is directors and officers do not have a duty to a person that's simply a beneficiary of the general or specific public benefit purpose. The act expands the duties of management, but it does not expand the scope of who those duties are owed to. And importantly, directors and officers cannot be held liable for personal monetary damages for an action that is performed in compliance with their duties or for the failure of the benefit corporation to pursue or create its general or specific public benefit purposes. So as I'm sure you're starting to understand that really the key themes here is these director and officer standards of conduct, they protect mission. Management now has expanded fiduciary duties where they must consider a variety of non-financial interests and factors. But at the same time, it also protects management because the consideration of these non-financial interests and factors, they won't result in liability for failing to maximize financial value. They are explicitly these things in the best interests of the corporation. And as long as management complies with these expanded duties, they will avoid personal monetary liability for actions that they take under the act. And just because management now has expanded duties, the scope of who those duties are owed to it does not also automatically get expanded as well. So then the second aspect of accountability is enforcement. And so, to this point, we've discussed and reviewed all of the unique statutory features of the Benefit Corporation Act and all the unique features of the Benefit Corporation. And all of these unique features, statute also creates a unique enforcement mechanism. The benefit enforcement proceeding is the only mechanism to enforce the Benefit Corporation Act's unique statutory requirements. In a benefit enforcement proceeding, there's only two types of claims that can be brought. The failure of a benefit corporation to pursue or create its general or specific public benefit, or a violation of an obligation, duty, or standard of conduct under the Illinois Benefit Corporation Act. So who has standing to initiate one of these benefit enforcement proceedings, and really who has the authority and the power and ability to actually hold the benefit corporation and management accountable for these voluntary commitments that they made to pursue these additional purposes and all these additional requirements. So a benefit enforcement proceeding can be brought directly by the benefit corporation, or it can be brought derivatively on behalf of the benefit corporation. So a derivative lawsuit is a suit that's brought in the name of and on behalf of a corporation. And derivative benefit enforcement proceeding can be brought by either a shareholder, a director, a person or group of people that own 5% or more of the parent company, or any other person specified in the articles of incorporation or bylaws. So the Illinois Benefit Corporation Act, it really gives shareholders, particularly minority shareholders, a lot of power to, enforce these unique corporate purposes and these unique transparency requirements. But at the same time, it does not, expand the scope and create kind of unlimited avenues for people to be bringing lawsuits and trying to enforce the benefit corporation purposes or duties. The standing is limited to these groups of people. And of course, the Benefit Corporation Act, it allows for flexibility. The benefit corporation is free to specify in its articles or bylaws other persons who can have standing to bring a benefit enforcement proceeding. So as I mentioned, there's two types of claims that can be brought in the benefit enforcement proceeding. The first is the failure to pursue or create general or specific public benefit. So, what's the remedy for that? Well, a benefit corporation cannot be liable for monetary damages for its failure to pursue or create. And a director and officer, as we discussed, also cannot be personally liable for monetary damages for the failure to pursue or create. So then what does that leave us? Well, that leaves us with the remedy of injunctive relief. So injunctive relief is a non-monetary remedy. And what it is it requires a party to either take a certain action or refrain from taking a certain action. The loser of the lawsuit does not have to go and pay money over to the winner. All that injunctive relief means is the party must take a certain action. And really, the intent of the benefit enforcement proceeding, it's not to create additional avenues of monetary liability. And in fact, the entire act is really focused on social purposes and general public benefit, material positive impact on society. It's not focused on monetary liability. The intent is really just to ensure that the benefit corporation actually lives up to its voluntary commitments. It's a voluntary election to be subject to these requirements. So the remedy for a violation of these requirements is generally just to enforce those requirements, to live up to the voluntary commitment. Now, the other type of claim is a violation of an obligation, duty, or standard of conduct under the Act. This is, of course, a little bit broader of a claim, but I do want to just be clear that this type of claim in a benefit enforcement proceeding relates only to the obligations, duties, and standards that are specifically created by the Illinois Benefit Corporation Act. It doesn't preclude lawsuits for breaches of obligations or duties that are, outside the scope of the Benefit Corporation Act. One type of claim for a violation of a standard of conduct that you could maybe immediately think of is the failure to consider statutorily delineated interests and factors. Management must consider those interests. And again, the intended remedy is injunctive relief to, force management to go back and redo their decision-making process, or whatever remedy would be appropriate in that context. Although I should mention in this specific instance, personal monetary liability could theoretically be possible. That exoneration I discussed, if you'll recall, was only for actions taken in compliance with their duties under the act. If they management doesn't consider all the interests they need to consider, they technically would not have been complying with their duties. But again, the intended remedy is injunctive relief, and this is a new, a pretty new form of entity. So these types of things are relatively untested. Here you have some other examples, some other potential examples of a violation of an obligation, duty, or standard of conduct under the Act. This is not intended to be an exhaustive list. But, again, you can see the intended remedy is injunctive relief. If the benefit corporation fails to deliver their annual benefit report, well, the remedy would, logically be just to force the benefit corporation to do so. And again, the point of the benefit enforcement proceeding is just to enforce, the voluntary commitment that the benefit corporation has made. So before we get into questions here, just kind of wrap things up with first just the three key features of a benefit corporation: is purpose, legally required to benefit the public; accountability, management must consider non-financial interests and factors; and transparency, there's an obligation to objectively measure and report on social and environmental performance. So going back to the beginning in that poll question, what we started off with. So, having gone through all these unique features and all these unique requirements, what does the benefit corporation mean for you? And what are some potential advantages that you could get from, starting or using the benefit corporation form? Well, I know some of you had said you were, considering starting a business that pursued social and environmental objectives. So, these benefits will start for you right away. Is you'll be equipped from the start to address that tension between purpose and profits. And it really, you can establish guardrails within the structure of the entity to really allow you to address that tension. And as you move forward with your business, you'll have a built-in kind of system to objectively measure and report on that performance. And in that way, not only does the fact that you are a benefit corporation, that simple fact, and all these additional duties and decision-making requirements distinguish you from, greenwashing and businesses that maybe aren't quite as legitimately sustainable and responsible as they say. But it also gives you a way to, objectively measure and report on that performance. And then, as you're growing your business and you're planning growth and planning expansion, and you can really have certainty, particularly if you're looking to attract outside investment, that, you're considering non-financial interests and non-financial objectives, won't expose you to liability. Or if you bring in investors, you won't have to be forced to kind of choose one or the other and compromise your mission. And that can lead to not only investment, but it can also lead to consumers and to business. And again, just if you're just maintaining established business, the the third-party standard and those features that allow you to kind of objectively measure impact are really a attractive option. And then I think in a lot of ways, when you're ready to exit your business is when the benefit corporation structure may even be most advantageous. You've been building a business based on a certain mission and managing it in a certain way. And with the benefit corporation structure, it can really give you some certainty that, just because you're phasing out, it does not mean that your mission has to phase out too. So with that, looks like we got a little bit of time for questions. I would just ask that you put your questions into the chat box just to make it a little easier for us to address them. And it looks like we already have some questions in here. So the first one is, do you have recommended resources for third-party standards for Illinois benefit corporations? As Josh discussed, there's a lot of different factors that you could consider in deciding which of the many third-party standards that are out there you would like to choose. Maybe the most simple factor is just cost and complexity. There are varying degrees of complexity. We mentioned the B Corp that is tends to have maybe some marketing benefits in the sense that it tends to be very well known. So it really does depend on your objectives. We have another question. Why a benefit corp versus a 501c3 or worker co-op? Again, that really depends on your objectives. A benefit corporation versus a 501c3 each has advantages and disadvantages. But if your objective is personal financial gain while having a positive impact, and nonprofits do not have owners. They're considered to be owned by the public, and they cannot issue dividends. If you build up a nonprofit, a 501c3 tax-exempt nonprofit into a large enterprise that's incredibly successful, there's no opportunity to cash out or sell the business. So a lot of that comes down to just your own personal objectives. I'll give a few more minutes if anyone wants to put something in the chat. And Joshua, do you have anything that you'd like to add?
I just want to thank you all for coming today, and I hope that you've found our presentation to be of use, and we will take any more questions if we have them.
So while we wait for questions, I'll just throw up our contact information here up on the screen. You should all be receiving a copy of today's slides. And then also you can learn more in the latest edition of Mr. Lane's book. And just to make sure I get this in here, today's webinar should not be construed as legal advice or the creation of an attorney-client relationship. All of the fun disclaimer language here. So I will leave the contact information up and just give everyone another minute or two if they have questions. But yes, thank you all for coming, and please feel free to reach out to Joshua or myself if any questions come up. So we have major differences with the benefit corp and L3C. Joshua, do you want to?
Well, I mean, first of all, there are a couple of things to note. First of all, is that one is in fact a corporation, and one is in fact an L3C is a kind of limited liability company. Excuse me. So, for example, a benefit corporation has a board of directors, whereas an L3C would normally be governed by managers. L3Cs are not subject to the annual benefit report. They are not required to report their social purpose according to a third-party standard. Those are restrictions that apply specifically to benefit corporations. Now, it's true that many of the same kinds of motivational factors that might cause a person to want to create an L3C would also influence them to want to create a benefit corporation. So if you are creating a new type of entity, then you may want to look at both kinds of entities and see which of them may be right for you. But they are different kinds of entities, but they do have similar motivations.
Yeah, and with any of these decisions, it is all extremely, context dependent and specific to the business and your personal situation. So, there's advantages and disadvantages of every type of business form. Okay, well, with that, I think we will wrap up here. But again, please feel free to reach out to us with any questions or comments. And we really appreciate everyone taking the time to be here today.